Welcome, everyone, and thank you for joining us for today's Paid Family Leave webinar for employers and human resources professionals. I'm Jen Donovan from the Branding and Stakeholder Engagement Unit here at the Workers' Compensation Board. And joining me is Courtney Valley from our Office of General Counsel, and she will be on hand to answer your questions. Today, we will provide an overview of New York State's landmark paid family leave benefit, including contribution benefit rates and updates for 2025. And resources to help you share information with your employees. We will be using the chat feature to receive your questions today. You may enter your questions throughout the presentation in the chat box located on the right side of your screen, but we will wait until the end of the presentation to answer them. Courtney will answer as many of your questions as she can, but if you have questions we do not get to today, or if you think of something after the session ends, we will be providing you with resources at the end of the presentation. Your name and email were given to us when you signed in today. However, if you have a specific topic you'd like to discuss more in depth with the board, please share that topic along with contact information in the chat box so the appropriate board staff can follow up with you. The chat settings are configured so that only panelists can see any questions or comments that come in, so you do not have to worry about others seeing your personal information. Before we get started today, we ask you to please keep in mind that the board is unable to provide legal advice, which includes guidance about what you should do in specific situations. If you have specific questions or concerns about a request for paid family leave, you should contact your disability and paid family leave insurance carrier, as they are the entity that makes the decision to pay or deny benefits. So let's get started. In today's presentation, we will provide a brief refresher on New York paid family leave and how it works, update you on the 2025 benefit and contribution information, review who is eligible for paid family leave, review key responsibilities as an employer or HR professional, go over some similarities and differences between paid family leave and FMLA, and highlight the many resources available to you. Let's start with a little background. In April 2016, New York paid family leave, the nation's strongest and most comprehensive paid family leave policy at the time, was signed into law. Paid family leave is employee-funded insurance that helps employees be there for their family when they're most needed. Because of paid family leave, workers across New York no longer have to choose between caring for their loved ones and their jobs, as we now have employee-paid insurance to help in these critical times. New York State paid family leave provides you with a structure to help your employees care for their families in times of need. Paid leave has been shown to increase workplace morale and employee retention. Fully funded by employee payroll contributions, New York State paid family leave provides job-protected paid time off to employees who need time away from work to bond with a newly born, adopted, or fostered child, care for a family member with a serious health condition, or assist loved ones when a family member is deployed abroad on active military service. In addition to paid time off, New York paid family leave also has strong employee protections. Employees are guaranteed to return to the same or a comparable job after taking paid family leave. A comparable job is defined as a position with comparable employment benefits, pay, and other terms and conditions of employment. Employees are guaranteed continuation of health insurance on the same terms as if they had continued to work while out on paid family leave. If employees contribute to the cost of their health insurance, they must continue paying their portion of the premium while on leave. Employees are also guaranteed protection from discrimination and retaliation. Requesting or taking paid family leave cannot be held against them. As an employer or HR professional, it may be helpful for you to know the kinds of questions employees are asking, which could help direct the guidance you provide and the materials you make available. These are the top questions to the PFL helpline from employees. We'll cover the answers to all of these throughout today's presentation. First, though, let's walk through a quick review of the three basic uses of paid family leave. We'll start with bonding with a child. Paid family leave provides both parents time to bond with the new child within the first 12 months of the birth, adoption, or foster placement of the child. Parents who work for different employers can take paid family leave at the same time to bond with the same child. Parents who work for the same employer can take it at the same time unless their employer prohibits it. In that case, they can take leave separately over the first 12 months following the child's birth, adoption, or foster placement. It's important to note that expectant parents cannot take paid family leave for their own pregnancy. They can take it after the baby is born because paid family leave is used to care for someone else. A parent may be able to take paid family leave before the actual adoption or placement of a child if an absence from work is required for the adoption or placement to be finalized. Paid family leave is also available for employees to care for a spouse, domestic partner, child or stepchild, sibling, parent or step-parent, parent-in-law, grandparent, or grandchild who has a serious health condition. A few other important notes for family care. Domestic partner is defined broadly under the paid family leave law. It includes people who are not related by blood in a manner that would bar marriage in New York State and are dependent on one another for support. For example, an employee may be able to prove that they're in a domestic partnership by showing that they own property together or have children in common. A legal relationship is not necessary. It doesn't matter if these family members live outside of New York State or even outside of the country. Employees can take paid family leave to care for their family member as long as they are within close and continuing proximity. In other words, present at the same location as the family member they're caring for during the majority of the paid family leave period. This may include necessary physical care, emotional support, visitation, assistance in treatment, transportation, arranging for a change in care, assistance with essential daily living matters, and personal attendant services. In order to take this type of leave, the employee's family member must have a serious health condition. A serious health condition is defined as an illness, injury, or condition that requires either inpatient care in a hospital, hospice, or residential health facility, or continuing treatment or supervision by a healthcare provider. The third type of leave is for assisting during a military deployment. Paid family leave benefits are available when a family member is deployed abroad on active military service, or who has been notified of an impending call or order of active service abroad and assistance is needed. Reasons for paid family leave for an active service deployment are the same as the military provisions of the Federal Family Medical Leave Act, or FMLA. They cover the employee's spouse, domestic partner, child, or parent. There are a number of instances where paid family leave will help, shown here on the screen. Now let's take a look at the program benefits and contributions for 2025. Eligible employees are able to take up to 12 weeks of paid family leave at 67% of their average weekly wage, capped at 67% of the New York State average weekly wage. An employee's average weekly wage is based on their last 8 weeks of pay prior to taking paid family leave. For 2025, the New York State average weekly wage is $1,757.19. That means the maximum weekly benefit for 2025 is $1,177.32. This is $26.16 more than the maximum weekly benefit from 2024. The total maximum benefit of $14,127.84 if the employee takes all 12 weeks is over $300 more than 2024. It's important to note that employees can take this paid time off all at once or intermittently, but it must always be in full day increments. A wage benefit calculator is available at the link on your screen. Paid family leave is fully funded through employee contributions. The contribution rate is reviewed annually and is subject to change by the New York State Department of Financial Services. In 2025, the payroll contribution is 0.388% of an employee's gross wages each pay period. The maximum annual contribution is $354.53. Employees earning less than the current New York State average weekly wage of $1,757.19 will contribute less than the annual cap of $354.53, consistent with their actual wages. To estimate deductions, you and your employees can use the 2025 payroll deduction calculator on the Paid Family Leave website. So to summarize the benefits and contributions for 2025, both the maximum benefits and the employee contributions are rising. The maximum weekly benefit is increasing from $1,151.16 to $1,177.32. The total maximum benefit an employee can receive is $14,127.84, an increase of more than $300 from 2024. Employees will pay 0.388% of their gross wages each pay period, capped at an annual maximum of $354.53. This is about $20 more than 2024. Employers can begin deducting at the new rate as of January 1st, 2025. Now that we've covered the types of leave, the benefits, and the costs, let's review who is eligible to take paid family leave. Most private employers with one or more employees are required to have paid family leave insurance for their employees. Public employers may opt into the program. Employees of public employers who are represented by a union may be covered if paid family leave is collectively bargained. For covered employees, eligibility for taking paid family leave depends on meeting specific requirements for the amount of time employees have worked for their employer. Full-time employees, including domestic workers, who regularly work 20 or more hours per week, are eligible for paid family leave after 26 consecutive weeks of employment with the same employer. Part-time employees who work a regular schedule of less than 20 hours per week are eligible after working 175 days, which do not need to be consecutive. Citizenship or immigration status is not a factor in employee eligibility. Paid family leave coverage is not optional for eligible employees. Employees can waive coverage if they regularly work fewer than 20 hours per week and won't work 175 days in a year, or if they regularly work 20 or more hours per week but won't be in employment with that employer 26 consecutive weeks. Seasonal workers are a good example of this, as they may work full-time but for only 3 months out of the year. If an employee meets the criteria for waiving coverage, the employer must provide them with a waiver form, which is also available at the link on your screen. Employees who properly file a waiver will not make contributions and will not be eligible for paid family leave benefits. Employers should keep a copy of an employee's waiver on file. If an employee's schedule changes such that they no longer qualify for a waiver, their waiver will be automatically revoked within 8 weeks of the schedule change. An employee can also voluntarily revoke a waiver at any time. If an employee's waiver is revoked, their employer will begin taking paid family leave contributions and collect any retroactive amounts due. Keep in mind, however, that any amounts collected in excess of the paid family leave premium charged by your carrier must be promptly returned to employees. Now let's review how employees request paid family leave and the employer's role in the process. Before applying, the employee must notify the employer at least 30 days before their leave will start, if it's foreseeable. Otherwise, they must notify their employer as soon as possible. Next, the employee will obtain the request form package for the type of leave they need to take. and complete the request for paid family leave, Form PFL-1, following the instructions on the cover sheet. They'll make a copy for their records and submit it to their employer. The employer must fill out their section of the form and return it to the employee within 3 business days. This information includes items such as the employer's address, FANE, employee's date of hire, and last 8 weeks of wages. If the employer does not complete their portion of the form, the employee can still submit the form and cannot be denied solely based on the employer not filling in their portion. Employees will submit Form PFL-1, the other request forms specific to the leave they are taking, and supporting documentation directly to the employer's paid family leave insurance carrier. They can submit the request before or within 30 days after the start of their leave before they risk losing benefits. It is the employee's responsibility to submit the completed request forms, not the employer's. In most cases, the insurance carrier must pay or deny benefits within 18 days of receiving the completed request package, or the employee's first day of leave, whichever is later. Employees can get paid family leave request forms from their employer, their employer's insurance carrier, or directly from paidfamilyleave.ny.gov/forms. If for some reason an employee's paid family leave request is denied, or they have another claim-related dispute, such as amount of benefits or timeliness of an insurer's decision, they may request to have the decision reviewed by a neutral arbitrator. The insurer or employer, if self-insured, will notify the employee of the reason for denial and provide them with information about requesting arbitration. Arbitration for paid family leave is handled by NAM, National Arbitration and Mediation. More information on arbitration is available at the link on your screen. As mentioned earlier, an employer may not discriminate against an employee for requesting or taking paid family leave, and an employee is guaranteed job protection with the same or a comparable job upon return from paid family leave. If an employer does not return an employee to the same or comparable job, terminates the employee, reduces the employee's pay and/or benefits, or disciplines the employee in any way as a result of the employee requesting or taking paid family leave, the employee can file a discrimination claim with the Workers' Compensation Board. An administrative law judge may order an employer to reinstate an employee, pay any lost wages, pay attorney's fees, and pay up to $500 in penalties. The process and forms are available at paidfamilyleave.ny.gov, or employees can call the Paid Family Leave Helpline for assistance at 844-337-6303. Paid family leave was designed to be easy for workers and employers. I'll now walk you through a checklist of employer responsibilities. Most private employers in New York State must have paid family leave insurance. You should ensure that coverage is in place. Generally, if employers are required to carry disability insurance, they are also required to carry paid family leave. This insurance is generally added to an existing disability insurance policy. Employers who are self-insured for disability must purchase a separate paid family leave policy or apply to the Workers' Compensation Board to self-insure. For a list of insurers offering paid family leave policies, visit the Paid Family Leave section of the Department of Financial Services website at dfs.ny.gov/PFL. Next, inform your employees. Employee handbooks and/or other written guidance to employees must be updated to include information on paid family leave. To make this easy for employers, we have posted model language on the employer section of paidfamilyleave.ny.gov. Employers can customize it or just fill in a few blanks and print as is. Next, collect payroll contributions. Employers should be withholding at the 2025 contribution rate as of January 1st, 2025. Next, offer waivers to employees who qualify for one. Employers should identify any employees who qualify for a waiver. These are employees who regularly work fewer than 20 hours per week and won't work 175 days in a year, or who regularly work 20 or more hours per week, but won't be in employment 26 consecutive weeks. If an employee meets the criteria for waiving coverage, the employer must provide them with a waiver form. As we shared earlier, if an employee waives coverage, they will not make contributions and will not be eligible for paid family leave benefits. Employers should keep a copy of an employee's waiver on file. Next, post an employee notice. Insurance carriers provide employers with a Notice of Compliance, Form PFL 120, also known as Notice to Employees, stating they have paid family leave insurance and providing employees key information about the benefit. Self-insured employers can get this notice by contacting the board at certificates@wcb.ny.gov. Employers must post and maintain this notice in plain view, similar to how the signage for workers' compensation and disability insurance is displayed. Employers who receive a paid family leave claim must complete the employer section, Part B, of the Request for Paid Family Leave, Form PFL-1, and return it within 3 business days. The employer will be asked to provide the employee's last 8 weeks of gross wages and calculate the average weekly wage. Employers should be sure to discuss any specific leave tracking or other processes with their paid family leave insurer. We are frequently asked about the similarities and differences between paid family leave and FMLA. There are several similarities between New York's paid family leave and the Federal Family and Medical Leave Act. Both provide leave for bonding with a child, caring for a family member with a serious health condition, and assisting when a loved one is deployed abroad on active military service. Employees are also guaranteed that they'll return to the same or comparable position, and their health insurance will continue on the same terms as if the employee had continued to work. If employees contribute to the cost of their health insurance, they must continue to pay their portion of the premium cost while on leave. But there are several key differences. Paid family leave is paid, FMLA is not paid. Almost all private employers will carry paid family leave insurance. FMLA does not include insurance, and it has a 50 employee threshold for eligibility. The length of time you must work is different. In paid family leave, if you regularly work 20 or more hours a week, you must be in employment for 26 consecutive weeks for that employer. And if you regularly work fewer than 20 hours per week, you must work 175 days for the same employer, which do not need to be consecutive. For FMLA, you must have worked for a full year and 1,250 hours in the last 52 weeks to qualify. The biggest distinction may be that under New York's paid family leave, you are taking leave to care for someone else, not for your own health condition. FMLA allows you to take leave for your own health condition. Paid family leave is only taken in full day increments. FMLA may be taken hourly. Also, under paid family leave, you do not need to use other paid time off first. There are several resources from New York State to help employers understand and communicate about paid family leave to their employees. Complete details on paid family leave are available at paidfamilyleave.ny.gov, along with other resources including paid family leave request forms and fact sheets, weekly deduction and benefit calculators, and more. There is also an Updates for 2025 page on the website that outlines the changes for 2025 and offers a number of employer resources to help explain and communicate benefit and deduction changes. These include FAQs, updated model language for employee materials, an updated template employers can use to provide notice of the 2025 payroll deduction, the employee statement of rights for paid family leave, and more. Visit paidfamilyleave.ny.gov/2025 to access these materials. You can contact the Paid Family Leave Helpline at 844-337-6303 for assistance. If you are not already subscribed for email updates on paid family leave, you can subscribe by clicking Get Paid Family Leave Updates on the bottom of the homepage. Finally, we also want to make you aware of the board's Office of the Advocate for Business. The Office of the Advocate for Business is the liaison between New York's business community and the Workers' Compensation Board, giving employers one place to contact for answers to their workers' compensation questions, as well as any questions employers may have about paid family leave as it relates to your business. You can contact the Office of the Advocate for Business at advocatebusiness@wcb.ny.gov. New York State paid family leave is administered by the Workers' Compensation Board. If you're not already following the board on social media, we encourage you to do so. We are on X, Facebook, Instagram, YouTube, and LinkedIn, so link up with us. You can also subscribe to get board updates on the other benefit systems we oversee, workers' compensation and disability benefits, by hitting Get WCB Notifications on the bottom of wcb.ny.gov. We hope you found this presentation helpful. Thank you for the opportunity to discuss New York's landmark paid family leave with you. We will now review your questions, and as mentioned earlier, please keep in mind that the board is unable to provide legal advice, which includes guidance about what you should do in specific situations. If you have specific questions or concerns about a request for paid family leave, you should contact your disability and paid family leave insurance carrier, as they are the entity that makes the decision to pay or deny benefits.
Great, thanks, Jen. So the first question we have here is, if our company acquires another one, will employees be given credit toward qualifying for paid family leave for their time at the other company pre-acquisition? So this is going to be extremely fact specific. It's likely going to depend on the terms of the acquisition. Generally, eligibility for paid family leave is calculated separately per covered employer. So if this is a new covered employer, the employee is likely going to have to regain eligibility for paid family leave, but it may depend on the terms of the acquisition. Okay, next question we have is, can a 1099 worker get their own disability insurance and paid family leave? And the answer is generally yes. If they are self-employed, so they're not an employee, they're truly an independent contractor and they're just contracting with you, generally, a self-employed individual can opt in for disability and paid family leave. You can find more information on the paid family leave website, and I'll pop the link down below. And this is about self-employed individuals and how to opt in. Okay, I see a few questions about whether or not the reporting and slides will be available. And the answer is yes, they will be posted on the board's website. You know, it can take a little bit of time for each recording to be posted up there, but there are recordings up there now, and this one will eventually be available as well. Okay, next question here is, I have always submitted the employee's paperwork. Is it okay to keep doing it that way, or should I change for 2025? So I can't provide legal advice, so I'm not going to be able to give you guidance about your business practices, but the PFL law and regulations do say it is the employee's responsibility to submit their completed request to the employer's disability and paid family leave insurance carrier. So it is their responsibility. There's nothing in the law that prohibits an employer from submitting it on the employee's behalf, but it is the employee's responsibility under the law and regulations. Okay, I see a question here asking about published guidelines for the New York paid prenatal leave that takes effect in January. That program is unrelated to paid family leave. So it is not part of the paid family leave law. It's part of the labor law and is unrelated, but there is a website that you can go to for more information. And I'll put that in the chat. And then questions can be directed to the New York State Department of Labor, but it is unrelated to paid family leave. Okay, next question here is, can an employee use their own paid time off while receiving paid family leave? The answer is that you cannot force an employee to use paid time off during a period of paid family leave. It's a wage replacement benefit, and you can't force them to use paid time off. But if you and the employee discuss and agree, an employee could use their paid time off to top up. We call it topping up an employee's benefits so that they receive full wages during a period of paid family leave. That's fine. They just can't receive more than 100% of their wages. Okay, I see a question here asking, can you please verify that paid family leave is not required by public employers? That's correct. Public employers are not subject to the paid family leave law. They can opt in if they choose. The first way for unrepresented employees would be the employer would opt in on behalf of the employees that are not represented, or if they are represented, they could collectively bargain to provide paid family leave, but it is not required. Public employers are not subject to the PFL law. Okay, next question here is, if employees can only use the benefit in 8-hour increments, can they take less than 8 hours and only be paid when they miss 8 hours? Or does that mean they will only be paid if they use 8 hours in one chunk? So paid family leave is not available hourly at all. It's either continuously, so weekly, up to 12 weeks, or it's intermittently, but the intermittent leave can only be used in increments of 1 full day. So it's not hourly at all. It's just 1 full day, or you're taking it continuously. So that is different from FMLA. FMLA can be taken hourly. Paid family leave cannot. It's intermittently in increments of 1 full day. Okay. Next question here is, at my company, it's 4 10-hour shifts a week. Do the employees still get 12 of their normal work weeks, or 12 regular 5 business days per week? So if the employee is taking paid family leave continuously and they're taking 12 weeks, they're taking 12 weeks of paid family leave. Their average weekly wage is going to reflect if they work before 10-hour shifts. I mean, it may end up working out the same as if they worked 5 days a week, but their average weekly wage is going to be calculated based on the last 8 weeks that they worked and received wages before the paid family leave. The other thing to keep in mind is just the only thing that this will kind of affect is if the employee is taking intermittent leave, they're going to be entitled to 4 times 12. That's going to be the number of intermittent days they work, because that's the equivalent of 12 weeks. So to calculate the number of intermittent days, you're going to be doing the number of days the employee works per week times 12, because the maximum is 12 weeks. But if they're taking it continuously, it doesn't matter how many days a week they work. They're taking 12 weeks of paid family leave. Okay, next question here is, which website are taxes paid to when they are deducted from the payroll? So paid family leave deductions are not a tax in the way we talk about taxes. It's a deduction that the employer can take in accordance with the PFL law to cover the cost of having their employees on their PFL insurance policy. So the deductions are there to cover the cost of the PFL insurance policy premium. So when you take deductions from your covered employees, you can only use those deductions to pay your PFL insurance policy premium. So you're going to be paying them to your disability and paid family leave insurance carrier to pay for the PFL insurance policy premium. Okay, a follow-up question here about the topping up. So topping up of the PFL does not impact their PFL benefits as long as they don't get more than their regular salary. So the answer is yes. If they're going to use like a third of a day or whatever it is so that they get from the 67% to 100%, that's fine. It's not going to affect their eligibility for PFL. It's not going to affect their PFL benefits. They just can't receive more than 100% of their wages. And again, you can't force them to use accruals during a period of PFL. Okay, next question here is, if it's a public employer who has employees that are both union and non-union, can the employer opt in for the non-union employees and then the represented employees join later with their collective bargaining? So yes, if you're the public employer, you can only opt in on behalf of your non-union employees. For the union employees to be covered, it has to be collectively bargained. So if you're going to opt in, you would have to opt in on behalf of the non-union employees, and then the only way the union employees are going to be covered is through collective bargaining. It doesn't have to be done at the same time. Obviously, collective bargaining agreements have different timelines, things like that. Okay, I see a couple more questions about the payment of deductions and where is it going to be recorded. The deductions are used to pay for your PFL insurance policy premium, and that is the only thing you can use them for. The board is not administering the deductions. We're not processing them. We're not doing anything with them. You are using that money to pay for your insurance policy premium. Obviously, your carrier is going to know if you paid your insurance policy premium or not, because you're going to have coverage or it's going to be canceled if you don't pay your bill. So that's really, I guess that's really kind of your record of payment, is that you're paying your insurance policy premium. That's the only thing that you can use the PFL deductions for. Okay, next question here is, if we're a public employer and we opt out of PFL for now, but decide to opt in later on, do all eligible employees have to participate? No exceptions. So if you're a public employer, you're not subject to the law, so there's no need to opt out. You don't have paid family leave because you're not subject to the law. if a public employer decides to opt in later on, you can opt in for some class or classes of employees, but there is no ability for an individual employee to opt out because they don't think they'll use it or they don't want paid family leave or anything like that. An individual employee cannot just decide they don't want to opt out. Same goes for an individual employee deciding they want to opt in. There's no ability for individual employees to do so. Okay, next question here is about how are office holidays counted in consecutive leave. So the interaction of holidays and paid family leave is not directly addressed in the PFL law regulations, and I can't provide legal advice. Generally speaking, if an employee is just on continuous leave, they're going to be on continuous leave regardless of if there are holidays in there. If we're talking about like an employee, for example, who's taking every Thursday off and then Thanksgiving is a holiday, they may not be able to take intermittent leave on that day because they would normally not be working on that day. Okay, next question here is, if an employee is eligible for paid family leave, can the employer count time off as PFL and remove it from their 12-week allotment even if they do not apply? So generally speaking, the answer is no. An employee can generally choose whether or when to take paid family leave. They're not required to take paid family leave. And the employer is not the one who's going to make the decision to pay or deny a request for paid family leave. That's going to come from the employer's carrier. So if an employee has a qualifying event but chooses not to take paid family leave, they don't have to take paid family leave. Time off that's not paid family leave is going to be subject to your normal leave policies. But no, generally speaking, you cannot unilaterally decide that time off is paid family leave. So it's a question about the website address where we can find the slides for this webinar. It's the paid family leave website, so it's just paidfamilyleave.ny.gov. Okay, next question here is, what if employees don't work the same number of hours per day? How do you calculate intermittent leave? Some days they may use 8 hours and some days they may use 10 hours. So there is no hourly use of paid family leave, so it doesn't matter. It doesn't matter how many hours an employee works. It doesn't matter if they work 1 hour, if they work 4 hours, if they work 8 hours, if they sometimes work 10 hours. A day of paid family leave is a day of paid family leave. So if they were prevented from performing work because they use paid family leave, that's going to be a day of paid family leave. It makes no difference how many hours they would have been working for. It's just, you can't take paid family leave hourly, so you're not using 8 hours of paid family leave, you're using 1 day of paid family leave, if that makes sense. So there's no an 8-hour day of paid family leave versus a 10-hour day of paid family leave. That doesn't exist. It's just 1 day of paid family leave if they're not working because they use paid family leave. Okay, I see an example and follow-up question about the topic we were talking about before, where an employee doesn't apply for PFL and wants to save PFL to extend their leave, but it's for FMLA and PFL. So when FMLA is involved, that is a little bit different. An employer can require an employee to take available FMLA and PFL for the same qualifying event at the same time. And there are regulations that support this that say, you have to notify your employee, you have to follow the regulations. But generally speaking, if it's FMLA and PFL and they're eligible for both, you can require them to take it at the same time if it's for the same qualifying event, even if the employee does not apply. Okay, next question here, somewhat related, is an employee can take FMLA first and then take PFL to care for a child, correct? And so, like we were just talking about, if it's available FMLA and PFL for the same qualifying event, an employer can require them to be taken at the same time. If we're talking about 2 different qualifying events, so for example, an employee gives birth and takes FMLA to care for themselves to recover from the birth, and then takes paid family leave to bond with the child, that first set of weeks where they're taking FMLA for themselves, that does not qualify for paid family leave. And so that would not be able to be run concurrently. So if the employee takes those days of leave, you can't say that's also paid family leave because caring for yourself is not covered for paid family leave. An employer can allow an employee to take FMLA and PFL for the same qualifying event separately if they want. But generally speaking, the same qualifying event, those leaves are going to be covered. They're going to be taken at the same time. Okay, I don't see any other questions, but if you have them, please feel free to put them in the chat.
We're going to give everyone just another minute, just in case anyone is typing your question right now. I did leave the screen up to our additional resources. You've got the helpline information there, how to get email updates. Be sure that you're subscribed so that you will be notified of future webinars coming up in 2025, as well as when a copy of this recording will be made available. And then we also have the Office of the Advocate for Business email up there if you have any questions related to your business. All right, it looks like that's all the questions that we have. Oh, we got one more.
Yes. Okay. So this is a follow-up question dealing with FMLA and paid family leave. So what if an employee is not eligible for FMLA at the beginning of paid family leave, but then become eligible? So I can't provide legal advice. This is going to be very fact specific. But when we say available FMLA and PFL, that means that the employee has to be able to take it. So you can't run something concurrently if the employee is not eligible for it. But beyond that is kind of too in the weeds and too specific, and I can't provide legal advice. But that's the general rule there. I see another question that just came in about employees who work rotating or irregular schedules. How is the amount of time calculated? So the regulations just talk about the regular work schedule. So it's going to be an average of the number of days per week they work, and then that's going to be able to, then you would take that number and multiply it by the 12 to get the number of intermittent days. Again, if they're taking it continuously, it's not going to matter because it's just going to be 12 weeks. And as far as calculating the average weekly wage, that's always going to be the last 8 weeks that the employee works and received wages before the period of PFL.
Okay, it looks like that's all the questions that we have. Thank you, Courtney, and thank you everyone for joining us today. Just a reminder, you can sign up to receive paid family leave news, including information on future webinars straight to your inbox. Visit the Paid Family Leave website, scroll down to the bottom of the homepage and select Get Paid Family Leave Updates. We also distribute information via our social media channels, so please follow the board on Facebook, X, Instagram, and YouTube. We thank you all again for joining us today and enjoy the rest of your afternoon.